This is still the conversation. Let's start off in Nigeria, where Nigeria's Supreme Court delivered judgment on governorship appeals in Kano, Plateau, Lagos, Zamfara, Ebonyi, Bauchi, and Cross River states. Now, of these states, those of Kano and Plateau are the most contentious. The final judgment on Lagos retained Governor Babajide Sanwo-Olu as governor. It also reversed the initial judgment on Plateau and Kano, retaining Muftwang and Yussuf as governors, respectively. Of course, Monday Mawa, legal practitioner, and Ladipo Johnson, spokesperson, New Nigerian People's Party, NNPP, joins me from Abuja at this moment. Thank you so much for your time, gentlemen.
Thank you.
All right, I'd like to start off with you, Ladipo Johnson. Oh, great. Now, I'd like to start off with you, Ladipo Johnson. I mean, your immediate reaction as regards the verdict for Kano State. What's your take?
Well, thank you very much. I believe, as with many of us who are from the NNPP and many of the citizens of Kano, that the Supreme Court has, in a mature manner, dealt with the two main issues before them and brought justice to the table in a well-reasoned judgment. We have maintained all along, that it was just not, it didn't make sense, the 165,000 votes that were deducted by the tribunal, and also the Court of Appeal coming to take the issue of membership that the tribunal itself had said it had no jurisdiction to take. So these two issues were the main things that the Supreme Court dealt with. And really, it was not rocket science, I don't think. But for one reason or the other, and the fact that it was a heated, it created a heated 6-month period from the elections. That's why there was so much tension. But we thank God that that has been sorted out now, and we hope that Governor Abba can continue with governance and working for the people of Kano.
All right. Now, what do you think actually happened at the first ruling? That's at the level of the tribunal. What do you think went wrong?
No, you see, I don't want to, going back to that is you're going to...
I mean, the case is out of court now, so I want to believe that, yes, I mean, you're at liberty to speak on it.
Basically, what happened at the tribunal, which made no sense to us, was that the judges of the tribunal came into Kano the day before delivering the judgment. Suddenly that evening, they were flown out of Kano and then delivered the judgment the following day via Zoom. And that judgment just didn't really make sense to us. You understand? And that was when they now said that 165,000 votes, that ballots that were not signed or stamped or what have you at the back, they voided them and removed the votes of Abba Kabir Yusuf. Although INEC had pointed out that these ballots were taken from the pad of ballot papers. You understand? So it didn't make sense to us. And of course, at the Court of Appeal, remember the CTC saga, where the certified true copy after the judgment had conflicting paragraphs at the end of the judgment. So these things were there looming large. And I tell you, my brother is going to speak. As a legal practitioner, forget the politics, forget my party affiliation. A lot of legal practitioners were not happy with the fact that Nigerians thought the judiciary was responsible for all sorts. But thank God, I believe that the Supreme Court has been able to, in a mature manner, I believe, settle things and restore some hope in the judiciary.
All right, I would come back to you, Ladipo. Let's go to Monday. Now, Monday, looking at the overall judgment, not just in Kano State, but that of Lagos, that of Plateau State, and of course, Zamfara. What do you make of the overall verdict so far?
Well, my brother, to be sincere with you, I'm not even interested who won and who did not win. I don't want to actually talk about other states, for instance, like Lagos. I'm not going to talk about Lagos, but there's nothing spectacular about the case in Lagos. I don't want to talk about this Bala Mohammed of this other state and some other few states. But there are three states that were most important to keen watchers. And one of those states happened to be Kano, then the other one happened to be Plateau, and then the Zamfara issue. My brother, first, before I even start or dive into the question, I want to first congratulate Nigeria as a country and then congratulate judiciary, an institution of which I'm also part. Because you see, when people talk about judiciary, they also bring us as lawyers into it when they are trying to criticize us. Sincerely speaking, when some of those judgments, particularly that of Kano, Plateau, and the Zamfara came up, some of us, we became ashamed of what happened. Now look at Kano, for instance, or let me not even go to Kano first, let me come to Plateau. Issue of Plateau was practically about issue of nomination. Now what the question was that there was they have to do Congress before the main primary of the political parties. And the law is that everything beginning from primaries to election day, before election day rather, let me simplify it. Everything from primary of a political party before election day, they are all what we call pre-election matters. And being a pre-election matters, the only court that had jurisdiction to entertain it is the Federal High Court and not the tribunal. So the only jurisdiction the tribunal has by virtue of our law is everything that transpired or anything that transpired from election day upward. Now, there are set of principles of law in respect of this, because anything that has to do with nomination, sponsorship, or withdrawal of candidate of political party, the law have always long been settled that they are issued that are within the internal affair of a political party. Apart from being within the internal affair of a political party, they are pre-election matters. And by virtue of Section 285, sub 14 of the Constitution, anybody that is aggrieved by a pre-election matter is to appear or apply to a Federal High Court within 14 days of the happening of the event. And more so, my brother, let me also quickly add this. And the only person that can also go to court is a person that participated in the primary election of his political party. In other words, if you are a member of Party A and I'm a member of Party B, and Party B nominated me, whether wrongly or rightly, whether I was qualified or not qualified, you who is a member of a Party B, you have no jurisdiction. Sorry, you have no locus standi, rather, I beg your pardon. You have no locus to challenge my nomination. So whether my nomination was valid or not, it is only a member of my party that can challenge it or question it. And not just a member of my party alone. It is only a member of my party that participated in the primary election that can go to court to challenge it. Not just every Tom, Dick, and Harry of my party that can challenge me. So it is now strange, contrary to all laid down Supreme Court decisions, rules on nomination, that the Court of Appeal will just open their eye in a very strange way and begin to sack elected officers from their various states.
So I'm sorry. So it looks like right now, from your breakdown, it looks like there is some sort of legal conundrum. both at the Federal High Court level, tribunal level, and then Supreme level? Because from what you've been able to deduce right now, you said that pre-election matters are mostly at the Federal High Court level, post-election matters, tribunal, and then maybe, Supreme, like we've seen so far. Now, I mean, one would believe that, men handling these cases are men of legal profession, they call them learned fellows. But right now, it looks like they are contradicting themselves, right? So what does this reflect of the judicial system, particularly when it comes to electoral matters like this? Does it not further complicate the issue?
Thank you, my brother. It's unfortunate, and that was why I started by saying I want to congratulate Nigeria and to congratulate Nigeria judiciary for what the Supreme Court has been able to do today. My brother, there have been several inconsistencies, particularly in this 2023 election. I participated in several election matters. For instance, let me give you one instance. There was a case in Lagos State. The gentleman was nominated. I'm talking about
Monday, are you there?
Lagos State.
Monday, are you there? Monday, if you can hear me, we, of course, have lost connection with you. But, of course, while we're still await Monday, let's go to Ladipo Johnson. Quite a lot has been said by Monday, just in a few moments. I want to, of course, go back to you concerning some of these legal hurdles. As a political party, how are you able to sort of navigate through this, many hurdles, given the complexity of many of it?
Well, you try your best as a party to first follow the guidelines of the umpire, which is INEC. You follow the guidelines, and then all these things come up or crop up and what have you. And you deal with them as they occur. We maintained all along that these, the one at the tribunal, that we maintained that it wasn't proper. We got to the Court of Appeal and it was something else. And we also felt confident in going to the Supreme Court, that there were a plethora of cases by the Supreme Court that had handled the issue of nomination or membership and has handled removal of votes or what have you. Even the Electoral Act was very clear about it. And that is why, unfortunately, along with the issue of the CTC that was contradictory, unfortunately, that is why we started to raise difficult questions, very difficult questions for someone like me, being a legal practitioner, wondering if there was a previous judgment before the one that was read at the Court of Appeal, things like that. And that's why I said I wouldn't like to go back to that, because they're very sensitive issues. But the good thing is that today, as Monday was saying, the Supreme Court has laid a lot of these things to rest. And I take it that moving forward, the elections coming up, Ondo and which state is it again?
Edo State.
And then Edo, and then in 2027, I think that there'll be slightly more clarity. You see, my brother, the jurisprudence, the philosophy of electoral law, we have to begin to look at it. When somewhere down the line, a few years ago, when they started to say that there were wasted votes, this and that and this, and remove the person, it's a dangerous thing for the country. Really, we should be looking at it that, okay, the people have spoken in this way. Should we use a technicality, or what sort of technicality can you use to usurp the will of the people, which is what democracy is about? So we have a lot of work to do as participants, political parties, members of the legal profession, INEC itself, individuals. We have a lot of work to do with the jurisprudence of our electoral law or electoral laws to make sure that we keep improving. I mean, every electoral cycle. We have a lot of work to do. We shouldn't just keep quiet after this one. We should look at the problems that happen. And I hope that our academics and seniors in the legal profession will take a lead. Look at those things that have happened and begin to talk to the National Assembly.
I mean, talking about issues or takeaways from this particular election cycle that we've seen a situation or a trend. I mean, it used to be, but this time around, it became really, really in our faces where, I mean, there is the electoral process where people cast their votes. The votes are counted, results are released, and then a candidate is declared winner. However, this issue is taken to court, and then the court usurps whatever is declared and declares a different candidate, in many of those cases, as the winner. And then the issue of, the mandate of the people versus the verdict of the court. I mean, you are a political party, you represent a political party. What does this portend for a political party like yours?
No, it's, look, let me tell you, these 6 months, right, talking about Kano, these 6 months have been more rigorous, there's been more tension than preparing for and fighting out the elections itself. It's been very difficult. I mean, there was euphoria after the court declared everything. I mean, read out its judgment today. I just sat down and I was just weak. It was like, wow, what a roller coaster. It's been more difficult holding on to your electoral victory than actually getting the victory. So you are very correct. It is not something that is palatable to political parties or to candidates themselves. You work hard, you take your message to the people, and you win. Yet you have some people who seem to know how to navigate another side of the electoral process, which was or is the judiciary. But again, let us thank God for what has happened. And let us pray that we all play our part to make sure that the Electoral Act is updated, that we cover the loopholes that are there. We look at the case law that we've had from the Supreme Court and ensure that these principles are enshrined going forward in an amended Electoral Act. That way, as I said, would have blocked some loopholes and we would have improved on it.
All right.
At the end of the day, yeah.
I'll come back to you, Johnson. I want to, of course, go back to Monday Marwa is back, online with us. Monday, you were trying to establish the legal, processes involved and all of the hurdles.
Yes.
But I would like to, of course, you to look at it alongside a trend right now that we are having where we have the vote or the will of the people versus court verdicts, obtaining some of this, votes. What's your take? And legally, from a legal standpoint, how can this be addressed?
Sorry for going off. I think I was making a point, but I will come to this, your question. I'm trying to address a very important issue before, for the sake of the public. Now, eventually, they did the submission primary and somebody emerged. And then they submitted the name to INEC. INEC said, no, they can't accept the name again. I personally handled that matter. I approached the Federal High Court. Federal High Court gave a judgment compelling INEC to accept the names. INEC was dissatisfied with that judgment and they went to Court of Appeal. Court of Appeal affirmed the judgment of the Federal High Court and the name was sent to INEC. Unfortunately, after the election, the INEC, the person that we substituted, the name still appeared on INEC website, but the main person was declared winner and the APC candidate went to court. The tribunal nullified the election on one ground that the Labour Party candidate did not show to court that he participated in all the stages of the election, contrary to the Supreme Court decision in Kogi State case of Audu and this Paleke case, that it is the man that has won does not need to prove again that he participated. Having won is deemed to have participated. The court nullified the election. We went to Court of Appeals. Strangely, the Court of Appeal affirmed the decision of the tribunal, stating that the man did not even show that he was properly nominated. And there are Supreme Court authority, and I'm happy today the Supreme Court has stated. My brother, I want to read to the public. I wanted to state it up here, but I want to quote what Justice Okoro said today. That the Court of Appeal has did so many wrong to many persons who were elected to represent their people, or by following the wrong provision that is not known to law. Justice Okoro stated this. Justice Okoro lamented that a lot of people have suffered because of the wrongful judgment of the appellate court, which had sacked several legislators who won the election under their platform of their political party. Now, what are we talking about? This not that there are no laws, not that there are no judicial authority, but someone begin to wonder why Court of Appeal, who is an immediate court to Supreme Court, will decide to begin to do things based on whatever they feel, ignoring the Supreme Court's laid down rules in many judgments. Now, this is very unfortunate. Now, look at it. People voted you into office, and they will now need to go to court for the court to test and now stamp your victory before you can now celebrate. I was discussing with a friend some time ago, and I was telling him, I said, from my knowledge as an election lawyer today, if I contest election and maybe the other person rigged me out or whatever, I will not approach an election court. The reason is that by the time you get to Court of Appeal, you don't know what you are going to meet there because of so much inconsistency in their judgment. And I'm
could it be as a result of, say, maybe...
And I make both to say what I'm saying this evening.
Could this inconsistency sometimes be as a result of political interference? Say maybe the power of the incumbent.
I don't want to say it's a political interference or whatever. But the point is this: every member of the bench took out of office to do what is right, notwithstanding whichever pressure is on them. There are pressure everywhere, my brother. We must learn to do what is right. Okay, look at what the Supreme Court has done today. Is there no president who is an opposition party, who is in the APC? But look at the Kano state case we're talking about. That might NMPP. Look at the Plateau, PDP. Look at Zamfara, PDP. But like I said earlier, I'm not celebrating whether PDP won or AMPP won. But what I'm celebrating today is that what we have today is victory for Nigeria, is victory for rule of law, and is victory for what is right. Because the truth is this: the very learned SAN, Olusegun Agbakoba, stated something sometime last year. He said before now, if you are going to court, you can't, when a client brings a case before you, if you look at this former state law, the former decided cases of the Supreme Court, you'll be able to state to a great extent, 70%, whether you are going to win or lose that case. He said, but this Court of Appeal judgment has become so inconsistent these days that you don't even know what you are going to get from court again. And it's quite unfortunate.
Now, how do we ensure, just because we're pressed for time...
Let me land. And the danger this protect to us is this: the day we no longer believe in our judicial system, might will become the order of the day. And that will be very dangerous for both judiciary and every other person within the society. When people can no longer trust judiciary. But thank God for Supreme Court today. Today I am proud I'm a lawyer. Today I am proud I'm a Nigerian for what the Supreme Court have done today. Because as far back as 2011, Supreme Court has stated that issue of nomination substitution is within the internal affair of political party, and that is not what the court is to look into. But we are surprised as to what the Court of Appeal they did this in 2023, and it's sad.
Okay, I mean, you said so much, but then again, one would question the role and the function of INEC in all of this. I mean, one would expect that an institution like INEC, particularly when it comes to internal party matters, INEC would do some sort of homework to ensure that at least that aspect is tidied up, and then you proceed to the proper elections. But right now it appears like, okay, people come out to vote. By the end of the day, they cannot celebrate yet until the Supreme Court gives a verdict. And that puts a big stain on our democracy. Because at the end of the day, you ask, why did we come out to vote in the first place? If a court, a 5-man panel can decide who becomes our next leader. So my question to you is this: how do we go forward? How can Nigeria move forward, in terms of its, conducting elections to ensure it's transparent, credible, and also builds trust, particularly with the voters? Because right now it looks like we are sloping, the country seems to be sloping, silently into political apathy, particularly electoral apathy. And we have, the Ondo elections and the Edo State elections coming up.
Thank you. Well, first and foremost, I want to apologize the way I was shouting. It is so painful. If you're a lawyer, you understand what I'm saying today. What I did over 7 election matters, and I know what I passed through. Now, coming back home, the point is that as a people, we have to decide what we want to do. We have to decide to do what is right, no matter who is involved. Now, look at it. I have been critical about INEC. As a matter of fact, I don't think any lawyer has done matters against INEC like I did last year. I did over 140 cases against INEC in 2022 to 2023. The record is there. Now, the point is this: the best electoral law that would have been able to save Nigeria and the INEC rules and regulation was the one, this 2023 and 2023 election, because INEC guideline and manual originally, I think paragraph 48 and 49, I hope I'm not quoting out of context, provide that all results must and shall only be transmitted electronically. And INEC came on air publicly to tell Nigeria that all the results, as you are seated at the comfort of your home, you will be seeing what will be uploading results. But what did we see? Nothing. So the point is this: INEC have to decide to do what is right. But of course, I am not against people going to court if they are questioning the decision of INEC. That happened in the United States in the election of Trump and Biden. After the election was conducted, Trump, a sitting governor, said a sitting president said he was not comfortable with it. And he went to court. And that is what I'm trying to say. We have to strengthen our institution.
All right.
Obama, in his last visit to Kenya, said that the problem with Africa is no longer strong leader.
All right, Monday, I'm sorry, but
strong institution, that we have too many strong leaders who are stronger than the institution.
All right, Monday, I'm sorry, but I might just need to cut in so that we can take, of course, Ladipo Johnson's final thoughts, because we are pressed for time. Now, Ladipo Johnson, you talked about the Electoral Act. Now, moving forward, particularly for future elections, what do you think should be added? If you can just give us, or modified, in 30 seconds.
Well, as Monday was saying, what we have now, or what we had, especially regarding INEC's modus that they said, are things that should be looked at. We need to keep moving forward. We need to elevate. But the bottom line, my brother, is not the laws, not the spirit of the laws. It is those who operate it. We, the Nigerians. You see, the whole system, when you are collecting money to vote for someone or to win your nomination, someone else is collecting money and it pervades the system, then INEC is part of the system. The judiciary are part of the system. The police are part of the system. So you see that cancer that has entered into us, that is corruption. From secondary school, primary school, university, churches, mosques, everywhere is corrupt. We have to begin to weed these things out. If not, you will never get anything right as a country.
All right.
The economy will not work, etc., etc.
All right.
These things are all interlinked.
All right, thank you so much, gentlemen. Monday Mawa, legal practitioner, and also Ladipo Johnson, spokesperson for the New Nigerian People's Party, NNPP. Gentlemen, once again, thank you so much for your time.
Thank you very much.
Thank you. Thanks for having me.
All right. Now, more than 23,000 people have been killed in Gaza since October 7th, according to the enclave's health ministry. That includes nearly 10,000 children. Now, in its 3-hour-long presentation at the ICJ judges, the South African team, led by international law academic and barrister John Dugard, articulated the harrowing plight of Palestinians in Gaza, who are trapped under siege, bombarded by continuous Israeli airstrikes, and attacked by a deadly Israeli military ground invasion. Of course, joining me right now on the program is Aliyah Vayez, African Affairs Analyst, joining from the United Kingdom. Thank you so much for your time, Aliyah.
Thank you so much for having me.
All right, great. Now, I mean, yesterday was, well, I call it a bit of a firecracker for those of, those that watched the proceedings. Now, what statement does South Africa, make? I mean, particularly with this move at The Hague, and of course, the fact that, I mean, one would not expect that an African nation can challenge a world power like Israel. What do you think this message sends to the rest of the world, particularly the Western community?
Well, I think, yes, South Africa, yesterday was a firecracker day, as you mentioned, an incredibly proud moment in South Africa's history as our legal team really presented a top-notch or almost legal master case of facts, irrefutable evidence, and, their best effort at kind of proving that Israel is conducting a genocide across Palestinian occupied territories. So I think, as much as it may strike some as a kind of a random country to say, to kind of lodge this case against Israel, if you look at South Africa's historical, stance towards Palestine, we as a country with a history of apartheid have enormous experience, not only with, what apartheid and tools of state oppression look like, but we have made our stance on Palestine historically clear that we are in favor of the freedom of Palestinian people and freedom is specifically from occupation. More in the present day, our foreign policy has been clear on this matter as well. Our Minister of Foreign Affairs, Naledi Pandor, has been very vocal about, our country's support of Palestinian freedom. Since not only since October 7th, but throughout her term, and broadly throughout the term of the African National Congress, our ruling party. More, towards your question, Dapo, on what happened yesterday, I think, as I mentioned, South Africa laid out a very clear and almost black and white argument breaking down Israel's action, from its genocidal actions to its genocidal intent. Using prima facie evidence, as well as contextualizing the 75-year-long occupation of Palestine without in not so many words condemning the actions of Hamas and the events of October 7th. But I think what is most important to take away from South Africa's legal argument yesterday is that it gave no room for the international community to doubt that under no circumstances is genocide acceptable or justifiable. Under no circumstance is genocide, a necessary action by state power, by a sovereign power towards, a people within or outside of its own sovereign boundaries.
All right. Now, one of the advocates representing South Africa, that's Adila Hassim, actually accused Israel of having perpetrated 5 main genocidal acts during this particular ongoing war. Now, I will just read some of the 5 to you, and of course, I'd like your reaction. The first being mass killings of Palestinians, the second being bodily and mental harm, and also another is forced displacement and food blockade, and also destruction of the healthcare system, and the final being preventing Palestinian births. Now, what's your reaction to some of these allegations?
Well, I think, South Africa, similarly to Israel today, they knew the audience that they were speaking to, right? This wasn't just, a black and white case where it's the lawyers, the defense and the judges, but they were speaking to the international community as a whole, where, South Africa very cleverly used this as a platform to illustrate the scale, ferocity, severity, and volume of violence that Israel has conducted against Palestinians in the past, since October 7th. And I think, highlighting or detailing not only the, immediate events or violences of the past, few months, but also the conditions under which Palestinian life is expected to continue. So, for example, the ongoing blockade, Israel's control of resources and borders, and the access to humanitarian aid. Advocate Hassim, rightly detailed to the world that context is indeed key, or context is indeed king. This is not something that is new. Palestinian life is 100% defined by Israel and Israeli policy. And I think what is immensely I want to say significant by detailing the nature of the violence or the nature of the past few months of this conflict is that Israel is
okay.
I'm gathering my thoughts. Is that
okay.
It helped to prove Israel's genocidal intent. It creates an atmosphere in which the violence that it enacts on Palestinian people is that of genocidal nature, where life simply cannot, not only continue, but life cannot thrive. And I think even, in the latter part of her statement, she spoke about the future of Palestine, what might happen after the conflict. So by taking out, for example, any aspect of Palestinian education, like universities, academics, etc., what genocide is not just now. There are, years and decades and generations to come that will experience the consequences of this genocide. And I think that's an aspect that is largely uncovered or perhaps unthought of by, for example, the media, analysis of this conflict, because of course we're preoccupied with the day-to-day events.
All right, so let's move away from the side of the Palestinians right now. Let's look at issues from the angle of the Israelis. Now, the Prime Minister of Israel, Benjamin Netanyahu, on Thursday, being yesterday, said that South Africa presented hypocrisy and lies at the court. Now, in the words of the Prime Minister, he said, "We are fighting terrorists. We are fighting lies. Today we saw an upside-down world as Israel is accused of genocide while it is fighting against genocide." I'd like to know your reaction on this statement.
Well, to be honest, Israel made its case today. It's, rightfully so. And as much as, supporters of South Africa and Palestine would want it to be a weak argument, they made, an airtight case for themselves, one of which was, to emphasize their right to self-defense, which we've seen Israeli Prime Minister Benjamin Netanyahu do time and time again. They have very strategically framed Hamas as a terrorist organization with an identity and character and actions that can only be described as, provoking Israeli military action, as well as, the argument of right to self-defense, and in doing so, the Israeli legal team today poked holes in not only South Africa's argument against Israel's right to self-defense as an occupying power, but also took apart every necessary provisional measure brought to the table by South Africa's legal case today in the ICJ, by saying that if you take away our right to self-defense, you are leaving us at the hands of a terrorist organization that has, proven in the past that it has terrorist intention, and our, civilians, our borders, our resources will be at risk.
Do you think South Africa actually has what it takes to pursue this particular case to a conclusive end?
I think it does. I think, it's got the not only the support of its foreign policy and of its government and ruling party, but I think, in the past, few weeks since the case was lodged in the ICJ by South Africa, at least a dozen countries all around the world have expressed their support. The heads of state have expressed their support. So, it is by no means South Africa standing alone, against, an overwhelming power. I acknowledge the fact that no major Western power has supported South Africa or come out in support of, South Africa's argument, if not its case at the ICJ at large. But I think, I think, Dapo, we fail to mention that South Africa is also very much drawn, put under the spotlight the credibility, the relevance, and the effectiveness of the United Nations system, at large. So I think under which the ICJ falls. So I think it's not just, it's not just black and white South Africa versus Israel, which South Africa as well as Israel have said they don't have, a quote unquote a problem with one another, on a bilateral level. I think this is South Africa saying, to the international community and to humanity at large, this is a time to wake up. And if you don't act now, there are going to be severe consequences.
All right,
so
Aliyah, just in 30
sorry.
Okay, just in 30 seconds before I let you go, how do you think the Jewish community in South Africa will take this particular move?
So I think we've got organizations like South African Jews for a Free Palestine who have come out in support of what South Africa is doing, what our government has stood for, what our foreign policy has necessitated. So I don't particularly think Jewish people by any means, around the world or in South Africa are in any kind of danger or at risk of any kind of harsh retaliation to what South Africa has said, especially because our legal team made a very strategic consideration and to define this case not on the basis of religion, not on the unlike the Israeli legal team, which very very poignantly made a religious argument of Jews versus for what they call Israeli Arabs, which are understood to be Palestinians. I think this is to reduce this argument to religion or to the safety of Jews versus Muslims or Jews versus Arabs, etc. is to reduce the question of humanity, which Palestine is fundamentally asking the world.
I mean, this, of course, is a very serious issue, and of course, we will keep our eyes on this particular ball. But thank you so much for your time. Aliyah Vayaz, of course, African Affairs Analyst from the United Kingdom. Once again, thank you.
Thank you very much.
All right. And that's where we draw the curtains on today's episode of the show. Please, it's important that we state that every opinion of our guest on the show remains theirs and not that of News Central. Many thanks to Tosin Adeyemi and her team. My name is Dakbo Adegboye. Bye for now.